Here's how a president can defeat a legal challenge without ever going to court. Make the lawyers afraid to file it. When President Trump returned to office, his administration used executive orders against major law firms, institutions that can test government power in court. Prominent law firm Paul Weiss had a civil rights legacy and had fought Trump in the past. It was threatened with crippling sanctions. Then Paul Weiss folded almost immediately and made a deal. 4 national firms fought similar executive orders, but 8 firms cut deals with Trump instead. Today, the New York Times revealed what happened next. A top partner sought a case against the administration to prove Paul Weiss remained independent. Internally at the firm, leaders objected. They were afraid to provoke Trump again, so the case was never filed. Paul Weiss says its independence was not compromised, but independence isn't what an institution says publicly. It's whether it will file the next case. That's how retaliation wins. It punishes past opposition until the target polices future opposition itself. Inside institutions like Paul Weiss or these big corporate law firms, surrender rarely sounds like surrender. It sounds responsible. Protect the clients, protect the jobs, protect the firm. But why should you care? Rights matter only when someone will enforce them. The government doesn't have to beat your case if fear keeps your lawyer out of court. That's what I call the retaliation reflex. Punishment instills fear. Fear becomes self-censorship, and self-censorship becomes control. That's how the powerful win and cover up injustice. I'm a civil rights and anti-corruption lawyer. Follow me because I show the receipts, explain what's the truth beneath the polished words, and track where people can still resist before compliance becomes normal.